I make the submission, please.
He came first minutes.
You don't want to mention, just mention
On matter minute 60, serial number 63 minutes.
63. We'll go by line, that is the only. 63.
But this matter was heard sometime. Minute.
Sorry to make you all waiting because of last day's meeting.
Only my lord directed me to produce a notification minutes, sir. Short point for consideration minute, maybe taken up for 30 minutes, sir. Because he is 82 years old, my lord. He used to say whenever he comes to my office, like he's in
63.
63 minutes. Yes.
What is it about?
Content matter.
What is it about?
But this is in respect of pensionary benefits.
Pardon?
This matter was heard, my lord, sir.
This
Your
is-
lordship directed me to produce notification.
No, in this endorsement has already been issued, Your Lordship. This is
Regarding
that
what
erstwhile
that is?
Shanvog.
This is contempt.
Yes, my lord.
The lordship directed me to produce 2013 notification, lord, sir. Those sandbox are entitled for 10 years entitlement of pensionary benefits. On 24th, 2024, I have produced the notification.
What is the direction? There is no urgency.
Direction.
It can come after.
Directly.
There's no urgency. Endorsement also has been issued in this matter, Your Lordship. He has not completed 10 years of service. These are those village assistants, Shanvogs, regularization and pensionary benefits.
We'll examine after 21st of October.
Obliged.
That's urgency minutes,
What is it?
because he is 82 years old minutes.
Oh, let's,
Pillar to post minutes.
we'll try whether it is urgent or not. 2:30.
Please.
My lords,
Without any
item number
commitment.
51, my lords.
Without any commitment on our part, we're keeping it. Yes.
My lords,
There is a-
item number
There
51.
is a threat,
Pardon?
there is a threat of eviction of the garment factory by the Panchayat Development Officer under the provisions of the Gram Swaraj and Panchayat Raj Act. It is the Panchayat which has to take the decision, not the Panchayat Development Officer. I sought for interim order from the learned single judge. It has not been granted. Any moment, orders are going to be passed. Therefore, I am seeking the intervention of this honorable court by filing the writ appeal.
Fine.
Tomorrow.
No, not tomorrow, after.
Otherwise, the garment factory will be demolished. More 450 families will be out of
Demolished.
lease
Why is it going to be demolished?
on the ground that the license has been taken for running of the warehouse and I am running a garment factory. This is the only reason.
So then
But it is not so and it does not make any difference.
tomorrow.
Please.
My lords, item number 51, my lords, due to some personal inconvenience, I will not be on the,
Yes.
for the petitioner, my lords.
Challenge to an order passed by a learned single judgment. But the acquisition has lapsed. But there is no possession is also not taken by me. But there was an order of status quo all throughout.
All online mentioning will be after physical mentioning is over. Yes.
All throughout there was an order of status quo. On 24th of this month, my lord, on 25th of this month, there was a notice issued to me by the BDA saying that if you don't show cause, I'll demolish the buildings, my lord. Day before yesterday, permanent structures are already demolished, my lord. There are other permanent structures, my lord, that they may demolish today. But my request for 230, my lord.
Demolish. Why?
My lord, in the teeth of the dismissal of the order, dismissal of the writ petition that was filed by me before the learned single judge. My lord, there was acquisition proceedings, my lord, I challenged. My lord, the acquisition has lapsed. My lord, there is no compensation paid to me, and the possession of the property was also retained by me. My lord, there are hundreds of families, my lord, in this property. My lord, BDA has issued, my lord, there is also a connected writ petition, which is in which a certain society is also claiming rival rights over the properties, my lord. Now,
Thing will happen within a week. Next.
my lord,
Reopen.
my lord, day before yesterday, there are already demolitions undertaken, my lord. Permanent structures are being demolished.
You are in possession.
I'm in the possession. My lord. I'm in possession. My lord, certain, I have multiple buildings, my lord, in the said property. Certain buildings are already demolished, my lord. Even today, there are JCBs standing in the scheduled premises.
Tomorrow.
Great.
67302
Pardon?
67302 petition actually case file ಮಾಡಿದ್ರು ನಮಗೆ ರಿಕ್ವೈರ್ಡ್ ಸೈಡ್ ಟು ಇಒಐ ಸ್ಟಾರ್ಟ್ ಮಾಡೋದಂದ್ರೆ ಎಕ್ಸ್ಪ್ರೆಷನ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಕಾಲ್ ಮಾಡೋರು ಸರ್ ಇದರಲ್ಲಿ ನಾಯಿಗಳಿಗೆ ಅಂದ್ರೆ ಮೈಕ್ರೋ ಚಿಪ್ಪಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಮಾಡೋರು ಸರ್ 100+ ನಾಯಿಗಳಿಗೆ ಮೈಕ್ರೋ ಚಿಪ್ಪಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಮಾಡೋರು ಎಷ್ಟೋ ನಾಯಿಗಳು ಸುತ್ತೋದು ತಡಿಬೇಕು ಮೈಕ್ರೋ ಚಿಪ್ಪಿಂಗ್.
Are you speaking in English? You are speaking in English or Kannada? What? Speaking in Kannada? Speaking. What is saying?
Dogs.
I can wait. After vacation.
After the 14-10 days. 14-10 days.
Keep it after vacation. 28th of October. No urgency.
Serial
This
number
matter, no
36, Your Honor, I can't. Serial number 36, short accommodation for the filing objection.
30,
36,
33,
36.
36. What is it about? PIL is there?
No, it is in a contempt.
Contempt or late? It will go to 4th of November?
Much of this.
Oh.
With my lord's kind leave, my lords. But this memo matter was moved, my lords, on Friday, my lords. My lords directed it to be listed today. It is not listed. My lords, there is a threat of demolition, my lords, of my wall, which is adjacent to the other property, my lords. There was an interim order granted by this honorable court. Unfortunately, my lords, it was dismissed for dismissed for non-compliance of office objection. I filed an application, my lords. Now, in view of the dismissal, my lords, the PDO is coming near the property today afternoon, and he is saying that he'll demolish that wall. I had moved this matter on Friday, my lords. My lords are directed it to be listed today. But unfortunately, it is not come. My lords, may kindly.
They have not removed the office of this.
But the difficulty is that, my lords, it is only the submission that I have to make, and I have to file an application which is ready. They are not,
So,
which I have filed it, my lords, which I have filed it.
so something is incomplete on your part.
Please, my lords, that is the.
Then don't say that it was not listed.
Please, my lords, it is only on the ground of delay that they had said. I have filed an application also to that effect. My lords, may kindly call it 2:30 or tomorrow, my lords.
Why?
But there is a threat of demolition, my lords. The wall which is standing in my house.
All of a sudden demolition started.
No, my lords. It is in pursuance of the order passed.
Where demolition started.
There was an interim order granted by this honorable court.
Because it is last day of vacation.
Absolutely not, my lords. In fact, this court, my lords, has granted an interim order in my favor. It is only tomorrow. Great. Very great.
My lord, serial number 50, my lords, list 1. My lords, kindly seeking short accommodation to file the additional objections in that.
Whatever date you want, whichever date you want, take it. 50?
50, list number 1, my lords.
Yes.
My lord, list 1, serial number 29, my lord.
Yes, ma'am.
My lord, here. The contempt petition, my lord, we need some time. We need to submit some certain documents. Adjournment may be granted.
Pardon?
We need to submit certain documents, so kindly time may be granted.
Which one?
29th matter, list 1.
29.
My lordship, may I mention one of the case, my lordship?
Take your date. Whatever date you want, give to.
Sir, I'm a part in person in a PL, which is coming for hearing on 28th of this month. That's an urgency now. One of the players in PL is not to mandate EST Kata for property registration unless the government enables EST Kata. But over the last week, the government has mandated EST Kata for entire Karnataka. So, but the system has not even been enabled. People can't even get the EST Kata, then they can't do registration. So all registrations will be in a standstill if this mandate is followed. So I want either tomorrow or the vacation bench so that I can present data points.
Vacation bench is for the vacation.
So tomorrow, if
We are not vacation, or we can tell the vacation bench to take up. If you want to go.
Okay, tomorrow, sir, because this is
Tomorrow not.
because this will bring the registration to standstill, sir. People can't do registrations, and government will also lose revenue, and they will be forced to.
There is no urgency to keep it tomorrow. Yes, next.
Any mentions through VC?
My lords, item number 51, my lords.
Item number 51, yes.
My lords, on the next date of hearing, I will argue the matter, my lords. Any date may be fixed, my lords. And for the petitioner.
What is it about?
My lords, this is a land revenue matter, my lords.
51.
Lords, wherein plantation crops are being treated as agricultural lands. And as per the report of the Auditor General's report, plantation crops cannot be treated as agricultural lands, and Section 95 of the Karnataka Land Revenue Act is not applicable to plantation crops, my lords.
They have challenged the constitution of the technical committee
This,
for
or-
land.
this order is passed by which authority?
Please, my lord.
The order at next array, which is
Yes, that is the order with
The technical
regard to
committee was formed.
constitution of a technical committee.
conversion of agricultural land for non-agricultural purpose in Kodagu district.
Yes, my lords.
That has been challenged, saying that this constitution of a committee is bad. But the constitution of committee, the object is only to give a no objection, not for giving a conversion order, which is the prerogative of a DC.
Page 40, no objection to be issued by technical constitute. No, this was pursuant to some,
My lords, issuance of NOC is challenged.
you, we'll take up after
Please, ma'am.
Much obliged, my lords.
4th of November. As requested by learned advocate for the petitioner. Not 4th of November. All. No matter on 4th November. This matter not.
So list number 2, seal number 1, Monisha NS.
This is separate.
May it please, my lords. Appearing for the learned counsel for the petitioner.
Same,
The,
these two. Yes.
my lord, the office objection regarding court fee has been
What
complied
is
with.
it about?
My lord, regarding the urgency is about the admission to the medical course. Now studying in 3rd year, may directly beg to draw my lord's attention to annexure D. Earlier college recognition was cancelled and they were relocated to a particular college. That college has not provided the admission. Now we are praying for admission to this Dr. B.R. Ambedkar Medical College, my lords. They have given the consent subject to the approval of the Honorable Court. Students who had taken admission in now, my lord, the problem was with the fees. With the GR Medical College, my lord, it was de-recognized. Then we were shifted to one more college, my lord, by the as per the orders of the state government, pursuant to the orders of the Sonal Code. That college demanded 3 times the fees. Earlier it was 10 lakhs and odd. They started demanding 32 lakhs, by virtue of which we were not admitted. Now, my lord, Dr. B.R. Ambedkar College, my lord, has come forward to give the admission subject to the same fees. In 3rd year, class have already started. On identical circumstances, the coordinate bench of this Sonal Court, my lords, consider the plea. May I pass on that order. Even this honorable court was pleased to, my lord, direct the continuation of education of the other students, my lords. At page 18. Since Dr. B.R. Ambedkar Medical College has come forward to give admission, my lord, some the same fees. If a lordship is pleased to grant the permission, my lord, our education would be continued. Otherwise, education is now stalled. This lady student petitioner, my lord, is now in 3rd year of MBBS. Instead of 10 lakhs, which was being earlier paid, my lords, now the demand is for 32 lakhs, which he is not able to. But my lord, Dr. B.R. Ambedkar Medical College has come forward, R7, subject to the same fees.
So what is communication B?
Annexure D, my lord.
B.
Annexure B, my lord, the communication stating that the fees should be paid. Page B is, my lord, page 14. It should be the same fees as mentioned by GR Medical College. This may kindly be read in the light of Annexure A, page 13, my lords.
So you have paid how many? What was the fee you have paid?
I have paid, my lord, 10 lakh and odd, my actually. 10 lakhs, 11,950. What was paid by me was that. In page 13, your lordship may kindly see. Now they fixed it to 32 lakhs 62,450. That was under challenge, my lords. And it's clearly outside their authority to demand this much amount, my lords. Therefore, we are unable to pay this amount. Therefore, the entire education is stopped. Admission is also stopped, my lords. You can't pursue the education. The question of transfer to similar institute where the other institute, my lord, has given no objection for admitting them, has also come for consideration, and this honorable court was pleased to consider that and allow the prayer, my lords. May I pass on that order, my lords, by the honorable coordinate bench on the same subject matter, same writ petition, connected writ petition. I have not produced it, my lords. Please to permit me, will produce that, my lord. In the certificate annexure D, my lord, B.R. Ambedkar has stated that they are ready to admit the subject same fees which is paid at GR Medical earlier.
You are admitted to Ambedkar.
Please, our prayer is to admit to Ambedkar, my lords, please. Ambedkar has said we will admit. Subject to same fees.
So annexure D is increased payment.
Annexure D, my lords.
Is the fee you are ready to pay?
Please, we are ready to pay that fees, my lord. They have specifically mentioned the middle, my lords.
What is the fee they are asking?
Please, my lord, B.R. Ambedkar to pay the fees as per the admission order given at the time of admission at GR Medical College. So we are ready to pay the whatever that we are paid at GR Medical College, my lords.
For the various prayers made in the writ petition, from including to direct respond number 3, Director of Medical Education, Bangalore, and respond number 4, Karnataka Examination Authority. To accept the fees paid by the petitioners at the time of for admission to GR Medical College and further seeking prayer to direct the authorities to transfer the admission of the petitioner to B.R. Ambedkar Medical College. Yes, this one of 7 hearing. The case is based on the premise pleaded inter-alia that along with the other students, not amongst, the petitioner was admitted to first year MBBS at GR Medical College, Bangalore, in the year 2021-22. The petitioner completed second year course in 2022-2023. The recognition of the state GR Medical College was cancelled by the National Medical Council. The petitioner, along with the other students, was required to be relocated. For that, order dated 11/1/24 was passed by this court, in writ petition number 2026 of 2023. It is further stated, paragraph, that several students have approached other medical colleges for admission, whereas some colleges have agreed to admit them by charging same fees paid by them at the time of admission in GR Medical College. Full stop. It was stated that this court passed order dated 2/5/24 in writ petition number 10382 of 24, permitting the transfer of the students from the colleges allotted, to the new colleges. It is the further case paragraph of the petitioner that Dr. B.R. Ambedkar Medical College and Hospital, Bangalore, where the petitioner seeks transfer, has issued certificate dated 25/9/24, agreeing to provide admission to the petitioner in the third year MBBS course by charging the same fees. Full stop. Learned advocate highlighted that writ petition number 10382 of 2024 involves similar set of facts in which this court has passed order, interim order dated 10/7/2024. In view of the above,
transfer order there
shall be, in view of the above, following order is passed. 1. Rule returnable on November 2024, by way of interim relief, it is directed that the petitioner shall be permitted to attend the classes of the third year exam.
Third year, my lords, third year.
But you are not admitted.
No, my lord, that order, my lords, there are 2 orders. I may pass on, my lords. Please. Kind permission.
Which order?
My lord, there are 2. One is that order, my lords. There is specific order.
But
by-
today you are in which college?
No. Now I am not. I was transferred to 6, respond number 6, but they are not given admission.
Then how can?
Or 6 because of the fees, my lords. This exact question, my lords. There are 2 orders, my
What
lords.
relief can be passed? And you
Please.
are not admitted to any college.
No, my lord, that question of transfer, my lord, is by the previous order of this coordinate bench, my lords. There. Page number is table. Page number 3, my lords. Second para, my lords, last para.
Since the petitioner is not presently admitted to any college, there shall be notice returnable. There shall be notices to interim relief. We'll keep a rule returnable on reopening, 21st. When the examination is starting?
The examination is in the first week of November, my
When?
lords. No, my lord, your lordship may kindly see, now you have to attend the classes.
You
Unless you
first-
attend the classes, my lords.
You first make your position clear that where you are going to be admitted.
7. Respond number 7, my lord.
Yes, admission. Without admission, how can we
No, my
direct
lord,
to?
without
direct-
paying the fees, they don't admit. This is like this, my lords. That's why your lordship may kindly see how this honorable court considered it.
Read the interim prayer.
The interim prayer is to admit to 7, that's all. The fees we are going to pay.
Interim prayer.
They have agreed, my lord. 7 has
This is your
agreed.
interim prayer where which you pray that you may be permitted to pay fees and admit in this number 6 college.
Please, my lords. May I beg to read with kind, my lords.
Where is that?
Prayer is to grant an interim order for transfer and admission of the petitioner to respond number 7. As per annexure D. My
Notice.
lord, annexure D. Now, your lordship may kindly see this honorable court, my lords, may I read one sentence? Please.
While learn rule returnable on the 16th of say 21st of October. Full stop. Learned advocate for the petition presses for interim relief. However, today the petitioner is not shown to have been admitted to any college. Therefore, the order permitting the petitioner to appear in the examination as was passed, interim order permitting the petitioner to in the examination as was passed in SCA number 1038.
No, my lord, that's it.
0382/24 cannot be passed. However, it is directed that the petitioner shall in the meantime pay the fees at the Dr. B.R. Ambedkar Medical College, respond number 7 hearing, in light of the letter dated 25/9/24, and the fee receipt shall be produced on record of the court. Full stop. So the question of further interim relief shall be considered on the next date.
Please, please, please. Yes, courtroom. Please, grateful.
Office objection shall be removed before next.
This number 2. Mr. P. Chinnappa.
For the complainant.
Comply with.
There was some mistake in the initials, my lord, that also we have corrected it. Instead of U, my lord, A was mentioned. That has also been corrected. And
Yes, madam.
Please, my lords. My only request is, my lords, we be granted liberty to revive. If at all, when I try to rejoin, they don't permit me, my lords, because I have to wrap up, my lords, and give
Now-
notice and then come back.
now that we have passed an order of reinstatement, my lord, it is for them to come and join. We have passed an order of reinstatement.
I received this
as-
order only on
as per the
Saturday, my
Order under
lords.
contempt.
Pursuant to order dated U-208/24, passed by this court, today when the contempt proceedings come up for consideration. Honorary of the respondent produced a memo dated 30th/9/24, along with which Honorary of Chandrakanta Arghavule produced memo dated 30th/9/24, along with which order dated 27/9/24, reinstating the petitioner. Copy of the order dated 27/9/24, reinstating the petition is produced. The petitioner is therefore to be reinstated as per the memo and the order passed by the respondent. It is directed that the petitioner shall be reinstated accordingly.
Much obliged.
Once the petitioner approaches the respondent to join the duties, full stop. In the above view, the contempt proceeding does not survive. Any further development adverse to the, in the event the reinstatement is not complied with, it will give rise to the aggravated form of contempt for the respondent. Right? Disposed of accordingly.
No, that observation may not be.
No,
necessary.
they will.
Because, my lord, they are supposed to, he is supposed to come and report
Will
himself to you.
last time don't say, will not pass.
Much.
But we are saying that he will report and he will.
Yes, obviously, my lord. We are bound to.
Much obliged.
Seal number 3. Vaishali agree.
This is a matter, my lords, which had come up last week.
This may take some time, my lord, so
That's but
can I request immediately?
We also need time to
My lords, I understand
out
what
what can-
lords, I made an offer, 101 crores I am willing to deposit. The ILMS, my problem is today IBM, that is the Indian Bureau of Mines, has issued a notice saying you are not showing the royalty returns.
Only worry is that before adverting to the merits, the matter is pending before.
Revision authority.
Revision authority said you sort out the issue relating to
Can I-
ILMS.
Can I request, my lords? I'm just not arguing. my lords.
Reopening.
No, I'll just reopening, my lords. Only thing is, my lords, the revision authority says sort out the issue with regard to thing. We have issued a notice to them to come out and give the amount, my lords. Roshi may have it immediately before vacation. If we can sit and sort it out, my lords, we'll sort it out, otherwise we'll argue the matter.
We can also go through what is.
I am, my lords, when the revisional authority,
because-
subject to my lords,
I have very cursorily gone through since.
lords, I am only saying this, once it was remanded, the revision, they have issued a demand notice for about 247 crores. Out of which 68 crores is the principal amount.
What is your prayer as such? You are
My
seeking
lords,
some
to unlock the ILMS.
transport,
Strictly speaking, my lords,
transport pass they want.
Yes, that system has to be opened.
And-
At least let me deposit the royalty. My problem is if I don't deposit the royalty, IBM is taking action against me. So when I send a DD, they return it without accepting it. For 33 crores, I sent a demand draft.
You are depositing the royalty.
To send, that deposit has been sent back. Now IBM says, you don't rectify your return showing the royalty, I'll take action. Now my problem is this.
You are voluntarily depositing the royalty well and good.
Is this sent back?
But in any order or any further proceeding, we may not take place today.
no, Your Lordship may, that's why I'm trying to be, my lords, whatever you have to deposit, let them sit with the authorities, let them calculate and deposit. So the only order passed by the revision authority under which is law to implement has come before Your Lordship, my lords, is to implement the settlement possible. So let Your Lordship may have it immediately after vacation. Let us sit across and sort it out if it can be sorted out, my lords. Otherwise, Your Lordship may hear them.
I gave this offer to the learned advocate.
I-
Out of
Not to me,
247
my lords.
No.
You think he has to give to the.
Lords,
According to you, what is the amount payable?
Well, according, there are two things, my lords. The amount payable according to the main order is 700 and odd crores, my lords. And the second demand is for 252.
my lords,
Two
in
crores.
both the demands,
Therefore, my lord,
principal amount was 68 crores. The first demand of 742 crores was challenged in the revision. They have themselves revised it saying there is an error in that because principal amount is 68 crores. They had calculated wrongly the interest part. Revising it, they have now issued a demand notice for 247 crores, in which the principal amount is 68 crores. I am only saying 68 I will deposit. The principal amount, the entire thing I will deposit subject to revision being decided.
my lord,
33 crores royalty I will deposit. That comes to about 101 crores. At least open the ILMS and I can at least rework with the IBM.
no, he doesn't have a valid mining lease. There's no supplementary mining lease also, my lord. Without mining lease, my lord, he cannot, it cannot be opened, my lord.
There is no order till date of locking my ILMS.
Then
There is no official order. If your lordship sees the present demand notice at 189, your lordship should get. It starts at 189, please come to 192. 68 crores is the principal amount. I am saying I'll pay the principal amount subject to decision in the revision.
the interim order is the nature of a final order, my lord, which cannot be granted at this stage.
Now, what is pending before the tribunal?
Identical
My lord,
affairs.
Revisional
I mean,
authority.
I'll just complete. I will not, my learned friend can. Lords, they issued a demand earlier. The dispute has been between us relating to calculation of royalty from 1995, 96 up to 2021, 22, my lords. 2 rounds of revision has been over. Every time the matter was being remitted back to the state government for calculation of this royalty. We have paid. They dispute the calculation of royalty. It's only royalty. Then, my lord, they issued a demand notice for 742 crores. In 2024, my lords. Precisely on 10th April 2024. 792 crores.
Then
we challenged it by filing a revision application. In that 792 crores also 68 crores is the principal amount.
68 principal and rest interest.
Interest.
Penalty.
Interest, compounded interest, my lords.
The other mine owners who have done the same thing have already
So
deposited.
this
I will
revision is
just-
pending.
That was challenged before the revisional authority. Annexure A is the interim order which was granted. During the pendency, ILMS, they have stopped not without any order. They have just blocked the ILMS.
The interim order is granted in your favor.
In the sense, my lord, sort out the issue relating to ILMS.
That is what is.
Yes.
That
To
is what-
open.
my lord,
Let me
why-
just complete. I do not know. My learned friend, he'll get his chance.
Then
Then, my lords, after this order is passed, a demand notice has been issued on 2nd of September 2024. Annex. Please come to page 189, my lords. 2nd of September.
$189.
Yes, my lords. A technical committee was constituted. Technical committee went again into the issue after the revisional order.
So this is demand notice.
Demand notice, my lords. In that, please come to.
So this demand notice
Is again subject matter which will be taken up in the revision, but please come to 192, my lords.
no, this demand notice in addition to that 740.
No, in modification of that. The report of the technical committee is at page 179, which said the earlier report of 792 was wrong.
All right. So this could be subject matter of revision again.
Again, it will be, my lords, because we'll have to, in the pending revision, we have to show. But what it shows,
Your file revision.
my lords, the earlier revision itself, we'll have to seek modification. Because the revisional, at page 192, the authority has again classified my principal amount as 68 crores. The balance, they say, is interest.
So according to this notice, what is the demand?
My lords,
According to this 2924, what is the demand?
demand is for, total demand is about 247 crores, my lord, 257 crores.
So reduced.
It is reduced because they themselves find earlier demand notice interest was calculated wrongly. In this, the principal amount is 68 crores. I'm only saying 68 crores out of this 257, it's only 68 crores is the principal amount. Now, my lords, my ILMS is blocked. I am saying 68 crores principal amount subject to adjudication by the revisional authority, I will deposit. Another 33 crores, which is the royalty amount, I will deposit.
If you are interested in the revenue, then
No, writ petition itself is not maintainable, Manoj. Let me point out, Manoj, your lordship, can you take that?
we are not hearing.
That's why I said, Manoj, if my learned friend wants to argue, I can take preliminary objection. And if you want to settle the matter in terms of the interim order passed by the revision authority, we are open to it. I won't argue
The interim order.
only to settle the matter. That's all.
For ILMS unblocking,
Well,
this offer, if my learned friend, my lords, he wants us to go to the department. I am giving an open offer of 101 crores. What settlement can there be, my lord, more than this?
Okay, leave it at that. We'll argue.
They
that
don't
matter on
even
merit.
come back on this.
So you are telling just as a first hand mediation that if you are interested in revenue, then you also
we are
have to
not-
set.
Let him pay the full amount, my lord. What is due, my lords? Yeah, and he's operated the lease without mining lease for nearly 1 year, my lords. 1 year without mining lease has operated.
That is not even an issue on hand.
Today you are operating your lease.
My lords, I have stopped because ILMS is stopped. IBM has stopped me because this royalty amount I am unable to fill. My lords, unless that ILMS is opened,
Lease at Bangalore. Where is that?
my lords, it's in Gulbarga, the
Gulbarga,
lease, my lord,
Gulbarga.
Gulbarga. It's the only thing, a cement factory. I have 3,000 people employed here.
So mining for which purpose?
Cement, limestone, my lords, which is used captively in the cement plant.
You are not paying royalty and go on.
My lords, I have paid the royalty. They say differential royalty. It's a dispute relating to differential
What
royalty.
is interesting is,
recalculation.
my lords, he doesn't put a weighbridge for nearly 9 years. And the royalty, what he had actually paid, my lords, he has not disclosed. When we find out, my lords, as per the clinker ratio, now he admits the principle on which we do it. The only question is, my lords, is what is the interest that is liable to pay? Principle is not in dispute, my lords. So therefore, my lords, what is the principle on penalty and interest which we have levied to other people, other mine lessees, my lords, is the same principle which is being applied to my learned friend's client. So let him pay that, my lords. So therefore, we'll be able to show on this.
We'll consider after it. It
Reo-
needs a little bit hearing.
Very well, my lords.
If it all to be, otherwise you have to act in accordance with the.
My
Please,
humble request is
reopening,
to my
my lords.
learned friend, it's not that we are, as your lordship please to point out.
So why the tribunal passes such an order to sort out the matter?
Go settle the matter.
Lords, ILM, because
Settle
ILM
the
is,
matter.
yes, no, not settled.
Order is to settle the matter.
Why?
Issue is this, my lords, there is no order to lock my ILMS.
Without going into, we'll not venture to pass any order.
Please.
That's the thing. 15, 16, 16.
After that, my lords, week after that, it will be.
My
21st,
hurry is,
my
my lords,
Only
both
3 working days on 14, 15, 16.
two cement
21st.
plants are closed.
21st.
So that working day is only 3, 14, 15, 16.
Please, my lords, can I request 21st,
22nd.
22nd?
Problem is both my cement plants are closed.
Will. But without understanding the whole controversy, will not venture to pass either order. And main thing is the revision is pending and you are due, you are.
My lords, in the revision, this ILMS, my lords, there is no order till date by them to block my ILMS. They have simply blocked it. I can understand if there is an order. There is not an order till date. Because they have control over it, they have blocked it.
What my learned friend is not saying is, my lords, it doesn't have a lease deed as on
My lords,
today.
I'll show that, my lords. It's
He says the
deemed extension is there, my learned friend
Your
says.
lordship may kindly see his pleading in the writ petition, page 90. He admits that the supplementary lease is required.
No.
Not my, page 90 maybe kindly.
Without,
I'll
please
read-
see my prayers.
But
My
then-
learned friend wants to pick up one prayer.
But his prayer says that he is ready to execute.
But he has to pay the money
Alternate
to
prayer.
execute.
Lords,
He has
that's
to-
why, if my learned friend, lords, what the state wants to insist is, without a supplementary lease deed, mining operations
Will
is
not waste.
illegal.
On
Please.
20.
That is contrary to Supreme Court's order.
Today, that it is not a today's matter because
Please.
last day, yes.
Grateful to.
So number 4. So Manjunath BS.
4, yes, 4. Same matter? Same?
No, my lord,
Is a different,
this is land grant for the ex-servicemen.
same, ne? Same.
Yes,
matter.
ma'am. My lord, as per the latest circular, they say that if the provided land is not available, whereas I have filed enough sufficient documents in my latest rejoinder dated 19/9/2024, which says, in pursuance to the materials mentioned above, as the land is free for disposal in all manner as hereunder for allotment of land to ex-servicemen. My lord, hence, my lord, this, even as per this circular, I'm eligible to be granted this land.
So we have held that the application dated 23/5/2000 has to be considered for seniority. And the deputy commissioner, the court is prima facie found that the deputy commissioner has violated the directions. And in order to give a chance to the deputy commissioner to comply with the order, the matter is relisted on 25/10/24.
So we have said that her application or his application, petitioner's application was found to be senior. The conduct of the deputy commissioner is contemptuous. However, still one more chance is granted to comply with the order. If not complied with, you can either comply with or resist the matter, whatever it is, your choice. But we will proceed in accordance with law in light of the observation of this order. That is made clear. So it is kept on which date? 25th of October.
Lords, may I have the copy of the order furnished?
Give copy. Once it is signed, we'll give. Copy of the order may be made available to learned edition.
My lord, would it be pertaining to survey number 218?
Why do you get, you are so much in hurry?
My lord, because that land is available, it's actually kept for ex-servicemen, hence I just wanted to.
There can't be a better order for you than. My brother has dictated on the behalf of people.
Much.
So wait till 25th. What happens on 25th? Wait till 25th of October.
Achha.
Something will happen on 25th.
Meantime, there is puja. In the meantime, there is puja.
Number 5. Mr. Manu
Just telling my
Prabhakar
learned friend, in the meantime, there is puja, so do some prayer also.
Dashera is coming.
But they've placed an order saying that they've complied with this court's direction. I must tell the court, we've also challenged that order in the writ petition that's pending before the learned single judge. There is only one point I just wanted to place for the court's consideration, and then I leave it to your lordship. The order, they placed a memo of compliance on 26/9/24. That order I've already preferred a writ petition against. I must tell your lordship that. With that caveat, please be kind enough to see page 30 of the contempt petition. According to me, even now, there is no compliance of the order, inasmuch as, I'll just read out one direction, my lord, and then I leave it to you. So if your lordships feel this can be urged before the learned single judge, I leave it to your lordship. Please be kind enough to see the directions at A. Clause 2 of the operative portion of the order, the learned single judge is modified, and respondent board is directed to initiate action against respondent 2. Needless to state, as per provisions of the Act, for the alleged violation of the terms and conditions of the lease cum sale deed. What they would do is purportedly take action under section 34, but increase the time granted to the allottee. That is not a scope available, my lord, as per the Act is my submission. So therefore, it is really not in compliance. Of course, I must tell your lordships, I've challenged that order separately before the learned single judge.
Interesting argument for single judge to consider.
Or the division bench, as the case may be. Of course, there was non-compliance with B that they've now complied with. That I must tell your lordships, in the sense that there was some delay, but they've passed an order. Right or wrong, they passed an order, and that order is subject matter of challenge.
In fact, my lord, pursuant to order passed under A, my lords, that is the impugned order which they have challenged before a single judgment.
That's what I was pointing. That's what I was pointing.
This is coming for first time?
No, my lord,
No,
it had come up
they had
earlier.
sought time multiple occasions for
We had
compliance.
sought for time for compliance. We have complied with it, which have already challenged the compliance order before single judge. Matter is
Compliance order is challenged.
challenged for
challenged
single judge, and single judge.
That's what I'm
is-
pointing out to you.
Final argument is there today, my lord.
That is
They've
what I'm
heard all
pointing
the
out to your
parties, my lord.
That is what I pointed out to your lordships, that I've already challenged that order.
And that also will
And-
be disposed of today, my lord.
No, hopefully. I mean, I didn't know that.
Because
It is kept for preliminary hearing today. I did not know it will get
no,
disposed today.
petitioner
Anyway.
finished arguing, respondents finished arguing, my lords. Only the KDB is to argue today.
I am only, my lord.
Who knows, he might be knowing.
Yeah, of course, sir.
No, my lords, if the petitioner and
This is on lighter.
On a lighter note, my lord, full-time advocate general, part-time astrologer, be that as it may.
They have to wait.
No, my lord,
it can be
that's the
disposed-
only reason.
it can be disposed
Can it
of.
be kept perhaps immediately after vacation? If it is going to be
It
disposed,
can be disposed of in view of the compliance, my lords.
Let court learn a single judge.
Please.
my lords.
21st
great.
or 22nd.
Please.
22nd.
I'm alone in front of another matter. Great.
So on that day, it might not survive.
Please, of course.
Please.
Of course. I got it. Great.
December 6, Anirudh Anand.
Lord, I appear for this is that contempt matter, my lord.
Is that invoice?
Yes, my lord.
So disposed of the IA.
In the backdrop of the facts and analysis, the court do not find any reason to hold that the respondent authorities have violated the interim order dated 6/10/2016. The court is not convinced that the request to produce invoices is a disobedience of the order, as long as the documents requested by the respondent are to satisfy itself on compliance of the interim order. Merely the petitioner is unwilling to comply with the directions. It is difficult to hold that the request would lead to disobedience, much less willful disobedience. No ground is made out to initiate contempt against the respondent authorities for willful disobedience of the order. The petitioner is free to produce the invoices as directed by the respondent authorities to demonstrate that the sale value on which 20% bank guarantee is provided is equal to the value of goods described in the tax invoices.
May make only
Accordingly,
one,
IA is rejected.
may make only one submission. This is the interim order is dated 6/10/2016, wherein my lords have said sale value. Lord, as per the definition, it is at the pit's mouth. But now, my lord, what they are asking is something contrary to what is stated in the interim order. My lord, they have no doubt opened it as I have filed it on the. But now they are asking for, my lord, in my contempt petition, they are asking for some documents. All that I am requesting is the interim order is very clear, which they have obeyed from 96.
We have held that the sale value for sale value, when they are asking for invoice,
Yes.
they are justified, and they're asking for invoice does not amount to contempt. That is what we have held.
But bank guarantee at sale value is, they are not accepting. That is the tragedy. Order of the court is that.
We have said in asking by them, the sale will, the invoice, there is no contempt. That is the sum and substance.
No, but not accepting sale value, my lord, amounts to that. All that I am requesting is only that. Nothing more than that. Sale value is very clear, my lord. They have to accept on that.
Their stand is that sale value is one reflected in the invoice. And
No, not in the invoice.
and we have found it reasonable, whatever it is, right or wrong.
Number 7, obligement. Mr. Mahendra Kumar Mitra, party in person.
This can wait after.
Yes.
November.
My lord, which date, man?
This can wait after vacation. Get the date.
Thank you.
This is covered by Justice Vikram Nath's judgment. before 2 months or 1 month, that there can't be an addition or deletion in the list.
I looked into it.
Supreme Court judge, yes.
Number 8, the sumo to writ petition PIL.
This also can go. 22nd.
This is number 9. Mr. Yatish, yes. Number 9. Mr. Yatish.
Okay, for the state. This
12th,
matter-
nobody is there.
This matter
12th
may
of
have become
November.
infructuous, my lord. This matter may have become infructuous. This is with regard to the OCI student.
That is.
Pursuant to the Honorable Supreme Court judgment, they've been permitted to participate.
This must be over. Everything is over and
Please.
must have been treated in accordance with the.
Please.
2:30. Who is appearing?
Mr. Yatish, yes.
Yatish. Wait till he comes to. Keep it tomorrow if he is not at. 2:30. For the time being. 2:30. We are assembling for that. No. 2:30.
Tomorrow, my lord.
Still number 10.
2:30.
2:30.
Leela P. Devadiga.
For the complainant, my lords, the amount has been paid with it. The interest has also been paid. Matter may be disposed, my lords.
What is
Complied with it.
It's been complied with.
learned advocate?
We may be
Mr.
given liberty to challenge the sale proceedings. if
What is
agreed.
your good name? Vasant Kumar.
Leela P. I'm appearing for Leela P. my lords.
What's the name? So and so, so and so.
Mridal Kutty.
Advocate, so and so is appearing for learned advocate Miss Leela P. for the complainant stated that the order under contempt is complied with. Full stop. The
My lords, we
compliance,
may be given
Amount is
liberty to
paid.
challenge the sale proceedings.
compliance is confirmed by learned and additional government advocate. Mr. Jafar Shah. Full stop. In view of the compliance, as stated by both the learned advocates, the contempt petition does not survive. It is accordingly withdrawn.
We may be given liberty to challenge the sale proceedings, my lords. There's been some deductions.
If the petitioner is aggrieved by the order passed on merits, form might be open for the petitioner to challenge the same in independent proceedings on merits in accordance with law. For in respect to it, this court does not express any opinion on merits.
Beautiful.
Still number 11, to Vasant Kumar HT. Still number 11.
Not
Appearing for accused, my lords. I praise for time, my lords. Senior is appearing for accused, my lords. I praise for time, my lords. We already filed complaints, my lords.
But it is complied with.
No, my lords.
Learn, you are Karthikeyan.
I am appearing for BS Karthik.
Order and contempt is complied with. That is what you stated last time. Not complied with.
My lords, senior is out of station, my lords. Senior is in out of station, my lords. I praise time.
You are not Karthikeyan.
No, my lords.
Who is for the petitioner?
To Vasant Kumar
Vasant
HT.
sir. HT Vasant Kumar, sir.
Keep it at 2:30. Come at 2:30 in the recess. At 3 o'clock.
Still number 12. Sachin BS.
For the respondent.
There is an interim order, my lords, which has come to be passed in this case.
Interim order.
Yes, there is an interim order which has already come to be passed in this case.
But it was slated to be heard.
And the one coordinate bench has already held a plea, my lords, of this honorable
So
court.
does not survive.
No, it survived, my lords. Everything.
Lords, we filed a contempt. We are slum dwellers. Lords, writ petition is allowed in our favor. Third round. After the contempt is filed, they have filed their writ appeals. One is by BDA, one is by BBMP. We were displaced in 1976 for road widening, my lords, by the then corporation. With an assurance we'll be rehabilitated in another place. Then, my lords, they issued the Hakupatras in our favor in a particular survey number. Then the corporation found that BDA had already acquired that land to which Hakupatras were given to us, and they had approved a layout. Those sites were given in our favor by collecting these nominal premium. Then, my lords, ultimately BBMP decided we can't find them land, we'll at least give them TDR, that is the transferable right, so that I can at least sell it and find a property for myself. That has become an issue going up and down, up and down. Ultimately, BBMP gave an undertaking before this court that they'll issue a TDR. BDA, which is only an issuing authority, my lords, under the Town and Country Planning Act, has been refusing to issue the TDR, saying that the compensation in respect of the land which they have acquired has been paid to the landowner, so we are not entitled for TDR. In effect, from 76, we have been displaced, struggling to get a place. Now, the learned single judge, after considering the entire matter, has directed them to issue the TDR. BBMP has actually no voice because we have filed a contempt, my lords. In the contempt, we have produced all these documents. The contempt also is tagged along with this.
What is TDR?
Transferable development right.
Section
That,
14,
my lords,
please, my lords, of the
Transfer
town
of
of
development certificate.
development right. Instead of giving compensation by way of money or, my lords, land, this is given, so it is as much as good
They're
as
saying that compensation is paid to somebody else.
compensation of the land has been paid to the real landowners of the land which had been acquired, but we are not claimed compensation. The corporation gave us Hakupatras to go to that land because we were displaced. Then corporation realized that land has been acquired by BDA. Now, my lords, we have been displaced. We have even surrendered our Hakupatras, original Hakupatras, to the corporation because they asked us to surrender, saying that they'll issue the TDR. Now, the learned single judge has only said, issue the TDR. Now, the issuing authority, BDA, will not suffer any loss because they are not giving any compensation. Corporation is the authority which has recommended for issuance of the TDR.
Appeal is by the Bangalore Development Authority.
Bangalore Development Authority. Oh.
So far as Bangalore Development Authority is
Second one is good, right? We are about 130 of us.
petition, lords, the first
So your
response.
rejection is based on some provision or just?
Lords, 14B of the Karnataka Town and Country Planning Act.
No.
Where, my lords, a
With
municipal
great respect
authority
to my learned friend, BBMP can't have a writ appeal itself. In the previous round, they've given an undertaking, they will issue the TDR.
BDA, my lords, has
Today, to turn around and say,
Today appeal by whom?
both by BDA and BBMP. BBMP had given an
Two separate appeals.
yes, two separate appeals. BDA, my lords, BBMP gave an undertaking to the court,
that,
to the
my lords,
division bench of this court.
Who gave?
BBMP.
Where is that?
My lords, that your lordship should get in the earlier contempt proceedings. If your lordship kindly come to our contempt, my lords, we have produced it. In contempt number.
It is
Six.
recorded by the learned single judge?
Yes, it is recorded. In the contempt, my lords.
May I only submit, my lords, this much. The learned single judge did not observe, my lords, a decision of this honorable court, a coordinate bench, please, my lords, in WP number 15101 of 2013, where the private respondent here was also a party there. It has been declared, my lords, by this honorable court that the Hakupatras which were issued by the then BDO, he had no, my lords, authority or locus standi to have issued it.
That's not so far as we are concerned.
That, my lords, I'll have to place this, my lords, a division bench order of this honorable court. This went up to the apex court, please.
In which we are
My
not
copy, my
parties.
lords, I'll pass it on. Jayamma, please, my lords, the first respondent is a party to that petition. I have only one copy, my lords, I'll pass it.
An issue of.
I made my markings, my lords, I'm sorry, my lords, may pardon me. And that matter went up to the,
So who is for BBMP?
I appear.
BDA?
I'm for the friend up there. And the interim order may kindly be appreciated. Detailed order has been written.
Really, the page number.
By a coordinate bench itself.
5101.
Really, the bill.
Only one copy, my lords. I
Please
seek my
come
lords
to
pardon.
page 156. Those are different people against whom CID has conducted an inquiry. They are now trying to mislead the court. Please come to 156 in the contempt, my lords. We have produced the earlier contempt proceedings where they have given an undertaking. In contempt 943. The order starts at 156. The contempt order starts at page 156, my lords. The cause title runs up to 182 because we are on. Now your lordship should get at para 3, page 184. In the bottom about 10 lines, counsel giving an undertaking, and they were represented by a senior advocate who gave the undertaking also. And contempt is closed by that.
What is that?
189, please come to 189, my lords, para 6 in that order. Page 189. It starts with in pursuance of to the order dated. Para 6. Shri so-and-so learned senior counsel for accused 1 and 2, that's the BBMP minutes. Submits that the corporation is bound by decisions dated 23/1/2019 and 1/2/2019, and they will recommend the names of the complainants to BDA for issuing TDR certificates along with necessary information and clarification sought by BDA in consonance with the impugned order passed by the learned single judge without any deviation. Said submission is placed on record. Then again, my lords, at para 7, the court records that they have already issued the clarification, BBMP. Ultimately taking their submission, it was dropped. Today, for the BBMP to say that we are not entitled for TDR, that meant, my lords, BDA opposing, I can understand. BBMP stand getting the contempt dropped in the first instance.
So I dispose of your on the basis of this. It is very clear. You have conceded.
I respectfully submit, please, my lords, what transpires is a coordinate bench has already held a please, my lords. But the judgment that I passed on just now, my lords, that was escalated to the apex court.
Oh, what happened?
That, my lord, there are some observations which are being made with regard to the validity of the Hakkupatras. Whether, my lords, the officer who has issued the Hakkupatra, as on the day, he could have issued the Hakkupatra in the first instance.
Who has issued the
Lords, the BDO did not have the power to have issued the Hakkupatra is what, please, my lords, the coordinate bench has already held. That judgment, my lords, I have passed it on. It is by a division bench of this honorable court. That was escalated to the apex court. Now that is attained finality.
Even petitioner has no title over the properties at all, my lord. Petitioners are the slum developers, my lord, residing in, my lord, has no title at all, my lord. I'll demonstrate, my lords, if my lords fix a date for hearings.
He will have this, my lords, immediately, please, my lord. That division bench is very
On
clear.
14th itself, my lord.
Lords, my learned friend, what reliance is being placed on the division bench judgment, those were imposters who tried to grab our land.
How the
The
petitioners are thinking.
very
my lord,
first
that
respondent-
Even they have no title over the properties at all.
And the very first
Based
respondent,
upon
my
the
lords,
Hakkupatras, my lord, issued by the BDO, they are asking for the TDR. My lords, TDR has to be issued by the BDA or by the BD, any authority, my lord. After the, my lords, cutoff date is there, my lords, in the year 2004.
this acquisition. please, my
After
lords,
acquisition.
1976.
Yes, my lord, 1976 was the utilization of land.
And by whom, nobody knows. And by whom? Let's see.
Lords,
Somebody
I
else
don't
has
know.
acquired it
BBMP
first.
is now saying all strange stories before this court after giving an undertaking.
Let's, my respectful submission, sir, there is a division bench order which has been taken up by the respondent as a party to that order. Jayamma, please, my lord, the very first party, my lords, in this, the respondent number
Lords,
on Jayamma.
that
She,
is-
my lords, an earlier round of litigation, my lords, where the division bench has passed orders against her. She is
Yeah,
a party to
those,
that.
Will you there?
Jayam, my lords, sir.
I'm not a party in that, my lord.
Yes, yes, yes. I have-
This order you are producing of 2019. What is the significance of this order?
My lords, that is not by us. There were imposters. That's what is recorded. There are CID reports which we have produced before this learned single judge, which said imposters are trying to take this land. We were not parties in that.
I
There
will
is a
demonstrate it.
categorical finding by the CID.
I will demonstrate it, my lords, that Jayamma is a party.
Again and again, my learned friend wants to demonstrate something which is not even urged before the single judge. The CID report itself is there before the single judge.
What was the direction to BBMP?
Lords, in the writ, there is no direction to BBMP at all. If your lordship sees the impugned order at page, your lordships are holding the contempt petition, my lords. In that volume 2, page 397.
397.
Volume 2 is the impugned order of the learned single judge.
Same here. Same. Once. Oh, 9.5. Yes.
The operative portion is at 469, my lords. Please see. Writ of mandamus to BDA to grant to the petitioners TDR certificates and report compliance. Should delay be brooked, Commissioner of BDA shall pay to each of the petitioners sum of ₹1,000. Respondent BBMP and other public officers on requisition by BDA shall furnish all necessary information, records to facilitate issuance of TDR. So the first,
So BBMP has published everything.
they say in the earlier things they have given. BDA is now raising an objection. So the learned single judge considers the entire thing records and issues a mandamus to the BDA. Now BBMP also comes and challenges this, though they are.
So we'll dispose of this BBMP's appeal
Well, that's what I'm saying.
and we'll examine all questions.
Very well.
Fair enough. All
Some-
questions.
No liability, please, my lords, on me. No liability because there is no direction.
We do not know. We'll.
No, no, there is no direction. That is the reason, not.
Then-
I appreciate, lords. What was read out by the learned senior counsel. There is a direction issued to the BDA.
Then why you are preferred appeal?
That's why, because of this reason.
there is
please,
no
lords, in
direction
earlier
against-
earlier instance, lords.
If
what I
your
have
view
asked-
is that no directions are against you, then why you have preferred
Lords,
appeal?
I'll have to, my lords, facilitate, please, my lords, for the issuance of TDR. That one direction, my lords, at annex clause 4, Roman 4 is also issued. In the direction, please, my lords, very specifically.
Only
These persons,
information.
Please, my lords, are not entitled, my lords, for the purposes of TDR. Then you should hit the scheme itself, my lords, of TDR itself.
There is a bar contemplated under law. Any land which is surrendered before 3/6/2004, TDR cannot be granted.
That's by way of an
All this
amendment.
has not been taken out by the
Writ
learned
appeal number 440.
My lords, that is VD appeal, my lords.
1 second.
Yes,
440 is by whom?
my lords, my appeal is that VD appeal is 440 of 2023.
Or where is the other appeal?
My appeal is 727.
Where is that 7? So, common order. Writ appeal number 440 of 2023 with writ appeal number 727 of 2023. Both these writ appeal arise from judgment and order dated 9th March 2024, passed by on a single judge in the writ petition number 2067 of 2022. Full stop. First mentioned writ appeal number 440. First mentioned writ appeal is filed by the Bangalore Development Authority. Original respondent number 3, whereas the other writ appeal number 727 of 20 has been referred by respondent number 4, Brihat Bangalore Mahanagarpalika. Both the appellants in their respective appeals are aggrieved by the directions which came to be passed by learners in upon allowing the petition. The relevant directions read as under an ABC, which is written 2, 3, 4. Paragraph. As per the above direction, the Bangalore Development Authority is directed to grant to the petition the transfer of development rights certificates without booking delay. Respondent number 4, BBMP, is required to furnish all the necessary information, public records, so as to facilitate the BDA, Bangalore Development Authority, to issue BDR certificates. There is a dispute about the entitlement of the petitioner to get the TDR certificate, which is the point inter-alia involved in this writ appeal, which would address the merits of the judgment and order of, in which the merits of the judgment and order of learners would be addressed. Full stop. When the appeal came up for consideration, learned senior advocate Mr. Phanindra for the original petitioner stated that they had an occasion to file contempt petition number 943 of 2023, alleging non-compliance of for the non-compliance of the aforesaid directions of learned single judge. Where is that page?
The directions, 469, the contempt. File X 460.
Yes. The contempt proceedings, contempt number contempt. The contempt proceedings, the state contempt proceedings, what came to be disposed of, came to be dealt with and disposed of by order dated 4th October 2021, passed by the division bench. It was pointed out by learned senior advocate for the petitioner contempt. Now, where is it in so long? Just find out. We don't have any security person here. No policeman sits here. Outside, what is doing outside? Sleeping? He must sit inside. Call him, make him sit inside from tomorrow, from reopen. So who's ring? Who's phone rang from? Lawyer? Litigant. Litigant. Where is the litigant? Ask him. Go there. Go there and tell him. For the petitioner complainant that in the contempt proceedings, respondent Bangalore, Bangalore Mahanagar Palika. Made a statement that they would be bound by the directions of a single judge about PDR certificates and the information to be supplied to the Bangalore Development Authority. In that regard, to be complied with by BBMP. Paragraph. In the order passed in the contempt proceedings, following paragraphs reflect the said statement and the stand taken by BBMP. So quote paragraph 6. In paragraph 6, the said stand is reflected. And further, in paragraph 7, following was observed by the contempt bench. Then paragraph 7, quote for in view of the above. Just warning. Don't seize senior citizen, just warning. Henceforth, we will seize it for a day. Yeah, leave. Just warning. Yes. In view of the above, stand taken and recorded by the recorded in the proceedings of the contempt petition, which led to disposal of the contempt proceedings. From it could hardly be said that the BBMP derives any locus now to challenge the judgment and order of learners and judges. Full stop. In light of above, the appeal, writ appeal number 4, writ appeal number, which was a 727 of 2024, filed by the BBMP, is not entertained on the aforesaid ground alone. Full stop. It is observed that all the questions of facts and law are kept open for the parties to be agitated in the appeal of the Bangalore Development Authority, which is a writ appeal number 44023. Full stop. Writ appeal number 4423 shall be listed for hearing on 25th of October.
Only submission is not matter went to the apex court. Apex court directed, please, not the special deputy commissioner to file a status report.
Pardon?
Matter went up to the apex court, please, not on a coordinate bench order. There, the apex court directed the special deputy commissioner to file a status report before the.
What the apex court directed? Where is the order? Apex.
It went up to the apex court.
Not us, my lord.
No, Jayambam Lords, one of the respondents, was a party there.
He is not the party, that's the.
He was a party.
No, what is the order of Honorable Supreme Court? Let us see. In any way, we kept every question open.
Yes.
Pass it on.
And that order is prior to the undertaking.
Prior to this contempt order.
Undertaking given, yes. It was all urged, my lord.
I'm bringing it to my lord's indulgence.
Yes, yes, we'll see it. We are bound to respect the order. So this is at the instance of. So how does it What is the bearing of this order to our order?
That's my only submission, is what is that these persons, please, not the private person, they would not be entitled for grant of PDA.
But then we are kept all questions open in the writ petition to be taken up at the instance of BDA, where you are also part.
I am also a partner.
All क्या लिखा last? Our all questions of fact and law ऐसे लिखा.
Recommendation
For the parties,
We'll make an application.
for all the parties
Please.
in the writ appeal filed by the.
Worry is if any liability arises on my head, please not be and we put out of that.
Then your statement will come in your way.
Recommendation. And he will recommend.
I will urge my contentions in the BDS only.
To the BBMP is only to provide the information.
Information, that's all. Because they have
Yes.
already, they have given.
No.
They have given information.
That my lords may observe. Not
That we have quoted the paragraph.
Please.
6 and 7.
Please.
We will not damage any interest on your.
Great.
You are entitled to raise all content, but for the concession given. That's.
There's an interim order operating.
Interim orders will continue to operate till the next. Right. So where is 720? 727 is disposed. So contempt is Mr. Phanindra, Mr. Counsel. Yes, contempt will survive.
Contempt.
In light of the interim order.
Interim order contempt may not serve.
May not.
Yes,
Serve.
it will be subject result of the.
Phanindra will have to be heard.
Contempt is by whom?
Contempt by the writ petitioner for non-compliance of the order passed.
So contempt will not survive.
No, but it was kept pending. Only after the contempt is filed, they have filed the writ appeal.
But now it will not survive.
There is a direction to BDA.
Let it. Let it. Contempt might be against both the parties.
It's number 13. Mr. R. Subramanya.
I appear for the appellant's counsel.
Senior is appearing.
Yes. Any urgency, Mr.?
Matter has to be heard. Though there is a stay order, my lord, I am also not allowed to function as the chairman of this committee.
That, this immediately after 15th at 2:30. No time.
15, 2:30, what is it? Please, no.
Or you.
Fine.
Though I have a stay order, my lord, I am as good as not functioning. They are not allowing me to hold any meeting.
15th at 2:30.
My learned friend has been, after.
Adjournment, my lord.
You are for appellant?
No, respond.
Appellant.
Please, no, 15th, 2:30.
To tell your client that it happens in the last days of it.
No, the best part is to make them come and sit. So,
Much obliged.
Number 2.
14. To Vinod Kumar M.
Interim order may kindly wait. In 13, interim order. Interim order may kindly wait. 13, man. Serial number.
13 will extend it. Interim order.
Complaint. My lord, my complaint was not registered as FIR, my lord. This honorable court directed the police to
That Lalita.
as per Lalita Kumar.
Lalita.
My
Well,
lord,
I have received the instructions and also an endorsement has been issued. Now, madam, there should be a cognizable offense for this to be registered. This arises out of an WhatsApp. Yes, sir, I will.
It's ready, my lord, because translations were required. I've received all the information. I'll find the.
My lord, my complaint is clearly reveals cognizable offense of forgery, mischief, and IT offences, my lord. That they are not.
Then your remedy may lie other than contempt.
Yes,
My
my
lord,
lord, even
if
in this
they
reference.
issue endorsement, then I can file writ petition.
No, endorsement is
Otherwise,
issued.
Therefore, we are directing them to.
No, we have issued endorsement. We'll file this one.
And once they issue endorsement, I cannot file a private complaint. A thousand of cases, this honorable court directed the police to register FIR as per Lalita Kumari case, my lord. But yet, in
Lalita
this
Kumari's case is
purposefully
only when there is
because
a
of
cognizable offense in this case.
political
Time is granted to the
forgery.
additional government advocate to file statement of objects from reply. 10 or to 24th October.
Much.
Yes.
List number 1. So contempt matters. Still number 1, Mr. Sagar BB.
I prefer the complainant, my lords. Lords, there is a delay of 528 days, my lords, and preferring the complaint. I have made an application.
Notice.
Obliged.
5th November.
Obliged.
Still number 2,
I appear for the
Ramraj M.
appear for the petition in this case, my lords.
Pardon? Same
sir.
notice, 5th November.
Still number 3, Mr.
Complaint.
Siddharth S. Gurukar.
Page 13, my lord.
Your Siddharth Gurukar,
Abhinay Vaiti, man. Abhinay Vaiti.
not Siddharth.
Second name.
Field, there is no appeal. 6th of November. Great.
This number 4, Akshay Kumar Jain.
It's complaint.
They have complied with the order of the single judgment.
You have complied with. Learned advocate for the complainant, Mr. So stated that the order brought under contempt is complied with. He further stated for the present petition does not survive for the petitioner. Accordingly, disposed as not surviving.
Much obliged.
This number 5, Mr. Anandaram K.
Last occasion, my lord, your lordship so pleased to observe that because of the pendency of writ appeal, unless, my lord, the state, lord, moves the writ appeal and some orders are passed.
We have filed the writ appeal, my lords. FR number has been given.
See the order 21/8/24. Unless within 2 weeks.
Yes.
And the appeal is coming up for consideration.
So, lordship may grant post the appeal immediately after the vacations, my lords.
What is the direction?
Direction, my lord, at page 27, my lords. Mandamus is issued. Mandamus is issued directing the fourth respondent to restore the name of the petitioner in respect of 4.5 cents in survey number 288 1F of Padavu village, Mangalore Taluk, which has stood mutated in the name of the state government.
As per the order passed on 21/8/24, date was granted time for 4 weeks to obtain appropriate orders. In the writ appeal, they proposed to be filed. Further observing that in the event any such orders are not obtained in the writ appeal proceedings, the respondents will be liable to comply with the directions of learners. Today when the contempt petition came up, learned additional government advocate Pramodinication stated that though writ appeal is filed, it is still to be posted for admission hearing. Full stop. Taking a lenient view, comma, it is observed that time to approve, time to get approved orders, time to produce the orders which may be passed in the writ appeal is extended up to 25th of October.
Obliged.
Full stop. Unless the order in the alternative, unless in the alternative, the respondent shall be liable to comply with the order, and the compliance shall be reported on 25th of October.
That's it may be tagged along with the writ appeal.
If the writ appeal is not, if the orders are not obtained in the writ appeal, and the directions are also not complied with on or before 25th October 24, so on. Who is to comply with?
Respondent number 4.
The Tahsildar
Tahsildar.
shall personally report before the court at 2:30 on the state day. It is observed that in the event occurring otherwise, as above, the presence will not be necessary.
Okay. Yes. Number 6, Srinivas K.
I appear for the complainants in the complainants, my lord, are the retired employees of the accused management who retired from service, my lord, in the year 2014.
So order is of 2016.
Thereafter, my lord, they have issued a reply saying that once the financial condition is improved, they're going to pay the amount. Annexure B series, my lord. But in spite of that, my lord, even after
Where is that letter?
my lord, Annexure C may kindly be taken, my lord. Annexure C, page 24. The reply dated 24/9/2016, immediately after the order passed by the Sambu court.
Is also in 16.
Please, my lord. What they have told is that once the financial condition improves, they are going to pay us. Thereafter, my lord, we have made repeated representations. And my lord, though the accused have paid the retirement benefits of other employees who retired subsequent to us.
Contempt of. It can't get extended. This
True, my lord, but because of the replies given by the accused management, we
assurance
kept
given in 16.
2016, my lord.
Even if you
But
count
kindly
the-
appreciate, my lord, the several cases are pending before the Sambu court.
Representative doesn't extend the. Even if you count the period of 1 year from the date of.
True, my lord, the limitation is there for a period of 1 year.
Even if you count the limitation from the date of the letter at page 29 Annexure C, the 1 year is over.
True, my lord. But kindly appreciate, my lord, this is a case wherein the complainants are retired employees. There are, my lord,
Direction was issued by a single judge. In
Order
order
is
dated 30th March 2016. So this paragraph 3. Don't write that. Following order was passed on 30th March 2016 by a single judge disposing of the writ petition. Then quote the entire order.
my lord, there are several cases, my lord, pending before the Sambu court against accused management.
Full stop. The aforesaid direction relating to interest on graduate was passed as back as on 30th March 2016. The contempt is alleged in respect of the said direction, which required the second, which required respond number 2. That's General Manager, Hindustan Machine Tools Limited. To consider the representations of the petitioner. Also, section 20 of the contempt paragraph, Contempt of Courts Act, deals with limitation for actions for contempt. It provides that no court shall initiate any proceedings of contempt, either on its own motion or otherwise, after the expiry of period of 1 year from the date on which the contempt is alleged to have committed. the direction was to decide the representative within 3 months from the date of the order of learned single judge, that is from 30th March 16. Full stop. The 1 year would reckon from 30th June, when the 3 months period would expire. Paragraph. Learned advocate for the complainant, Mr. So and so, comma, when confronted with the aforesaid aspect of limitation, comma, tried to submit that on 24/9/16, the company, respondent number 2 had, respondent said, given a reply to the representation, stating that there is a financial crisis in the company. Full stop. Even that letter was of 24/9/16. The petitioner set ascetic tight for all the years. Full stop. Even if counted from the said date, that is 24/9/16, the limitation for initiating the action in contempt has expired. Full stop. Full stop. It was then tried to be submitted that the representations were pending. Full stop. Mere pendency or repetition of representation would not have the effect of extending the statutory period of limitation for starting the action in contempt. Full stop. The present contempt petition cannot be therefore entertained on the said ground alone, as is barred by limitation.
Lord, liberty may kindly be read. Liberty may kindly be reserved to fresh file, fresh writ petition, my lord. Liberty may kindly be reserved to make representation and to seek for, my lord. Otherwise, my lord, we are earned benefits are going to be, my lord, because of the lapses on the part of the accused management. Till date, my lord, they are saying the very reason they have not received the financial aid from the government. Kindly say appreciate, my lord, this is the earned benefits, they cannot be denied, my
They are
lord.
bound by limitation period.
True, my lord. Liberty may kindly be reserved to make fresh representation and agitate their grievance. Otherwise, my lord, they will be deprived of their earned benefits, my lord. Gratuity amount itself is not paid.
If you want to make representation, withdraw the contempt.
I may be permitted to withdraw. I'm sorry. I'm sorry.
6 permission to withdraw the contempt proceedings, stating that the petitioner would opt to make a representation to the respondents for the purpose of compliance.
Please.
Also, while such permission to withdraw the contempt petition for such reason is granted, this court does not express any opinion either on the subject matter grievance or in respect of the recourse which may be taken by the petitioners.
December 7,
Opinion on
G1
merits.
Kumar.
I appeal for the complaint. So order passed by the learned single judge is at page 10, my lords.
Writ appeal here also has been preferred, my lord.
Against this writ petition, my lords, to my knowledge, no writ appeal has been preferred.
FR number is 1060 of 2024.
Direction given, my lords, could get it at page number 13, my lords, para 5.
Notice.
No case, my lords, to my knowledge.
So your lordship may kindly tag along with the writ appeal, my lords.
Writ appeal is filed.
Writ appeal is filed.
Listed with writ appeal number so and so so and so.
1060 of 2024, FR number.
1060 FR number.
FR number.
Then get it listed.
We'll get it,
This-
my lords.
Hold on.
This
Send
writ
out to
appeal is
22nd
filed after
October.
we filed contempt petition.
Send out to 22nd October, within which time the office of decisions, if any, in the writ appeal shall be removed and the writ appeal shall be listed on 22nd October,
Much.
Okay.
along with the contempt. 22nd
December
October
8.
2024.
Narayan Bhatt.
appear for the complainant. My lord, the operative portion, my lord, is at page 71 of Annexure C. My lord, paragraph 16, my lord. Page 71. My lord, this is in respect of promotion. My lord, to the post of professor and associate professor.
All right, notice 7th November.
Number 9,
My lord,
not MD.
my lord,
Number 9,
my lord. Serial number 9. My lord, the complainant's counsel seeks for some time because he got discharged from the hospital on Friday, my lord.
25th of October.
Obliged.
number 10, Mr. Shiv Shankar K. Number 10, Mr. Shiv Shankar.
Nobody, 25th of October.
Number 11, Sridhar Murthy.
For complaint. Order passed by the coordinate bench of the Sama Court is at page number 11 onwards. Direction is against accused at page number 14, para 4. Order passed by the coordinate bench of the Sama Court is at page number 11, and direction is against accused number at page number 14.
11th November.
Published. Yes.
Number 12, to G.S. Subrao.
But an undertaking given before the court is violated, my lord. Page 15 is the undertaking on 4/3/2020. With regard to non-alienation, subsequently there has been, my
This
lord,
is before whom? You can go to the same court.
correct, my lord, this was, my lord, this is an undertaking given by, my lord, the defendant.
The order which is brought under the contempt jurisdiction of this court by invoking the provisions of Contempt of Courts Act 1971.
But what has happened is, my lord, proceedings are stayed.
17 is the order.
But, yes,
Reads as under, passed on 16th,
4/3/2020 is the order.
passed on
4/3/2020, my lords would get it at page 17.
2020.
Defendant counsel files a memo stating that they are not intending to sell the property.
So
Till the
court, page 17, bracket, full stop. There is no gainsaying that paragraph after quoting the order at page 7. There is no gainsaying that the petitioner has remedy of filing the breach of injunction application. Filing the application for breach of injunction. In the event the violation of the aforesaid order is alleged, comma, is to be alleged, comma, under order 39, rule 2 capital A of the Code of Civil Procedure 1908. On the aforesaid ground alone, the contempt jurisdiction is not exercised by this court, relegating the petitioner if so advised.
In fact, the proceedings before the trial court are stayed.
Recourse in accordance with law.
The proceedings before the trial court are stayed, therefore, my lord, I am unable to.
And is disposed of accordingly.
Number 13, Mr. Nataraj HT.
There is a delay of, my lord, 505 days, my lord.
Huh?
There is an order passed by the division bench, my lord, where is, my lord, parties to maintain a status quo so far as suit for declaration and consequential injunction. In spite of, my lord, the order passed by the court, my lord, they tried to, they were.
The order brought under contempt, it could not be disputed by learned advocate for the petitioner that the order which is brought under contempt jurisdiction is an interim order dated 29th January 2020, passed by the bench in the regular first appeal. It required both the parties to maintain status quo until further orders. If the breach of the aforesaid order is alleged, comma, the remedy is available for either of the party before the same court to file a probative application. Full stop. Leaving the parties at liberty to move such application and work out rights and remedies in relation to the breach of the interim order, comma, and further in view that the order being interim order does not determine the rights of the parties finally, comma, this contempt proceeding is not disposed of accordingly without expressing any opinion or merits.
Number 14, Mr. Shankar Narayan Bhatt.
On the petition of the
Notice returnable on 6th of November. Notice.
So number 15, Mr. Vivek Ulla. Single judge's orders at annexure E, page 73, Your Lordship. They ought to have dispersed an amount of 38 crores within 6 weeks. This is order is dated 10/4/2024. By the month of June, they ought to have paid.
Interest.
It's not interest, principal amount, which they have agreed.
No. Your contempt against non-payment of interest.
Not about interest, the principal amount itself. The interest part, the Honorable Single Judge had given.
Page 80.
Yes, ma'am. Ma'am, what had happened, ma'am, during COVID, we had supplied PPE kits to the government to the tune of 78 crores. During pendency of the writ petition, my lords, half the amount was deposited.
So this 38 lakhs, 38
Is the
crores
principal amount.
is not released.
No, ma'am.
Is not released.
No, ma'am.
It is towards what?
This is the towards the PPE kits that were supplied to the government during COVID.
Notice written.
As may I request an earlier date, the only reason is this, my lords. There are banks who have initiated recovery proceedings against me for non-payment of this money.
22nd October.
Okay.
You can take always a defense that contempt is, the contempt is.
My lords, the problem, my lords, under the IBC, the only thing that the tribunal looks at is a debt and default. And if there's a default of more than 1 crore, the tribunal is bound to admit the petition against me. That's the only urgency, my lords.
NCLT.
NCLT.
Number 16.
Great.
So BC Sitaram Rao.
I appear for the complainant in the matter, my lords. Directions, I appear for the complainant, my lords. The directions of the single judge in the manner of mandamus, my lords, is that
12th November.
Number 17.
Appear for
So,
complaint in this
Muralidhar?
case, my lord. Direction is at page number 27 for payment of arrears of salary. It has not been paid fully, my lord.
Notice 12th November.
Number 18. Rajshekar S.
For the complainant, my lord. The order passed by the learned single judge in the page number 18, my lords. Directed the respondent number 3 to consider the
Notice
representation.
13th November.
Number 19. Pawan Chandra Chetty.
I am for the complainant, my lord. My lord, petition, in the writ petition, my lord, petitioner sought a writ of mandamus, my lord, to direct the respondent 5 to 7 authority to conduct a survey in respect of survey number 23, my lord. My lord, the direction of learned single judge is on the page number 30, running page number 30, my lord. My lord, para number 8. My lord, learned single judge disposed the matter in the light of the memo filed by the respondent authority, my lord. The proceedings under section 136 subclause 3 of the act are to be disposed of while taking note of the observations made above, and once 136(3) proceedings are concluded, the Podi and Durst proceedings are to be concluded within a period of 6 months, my lord. My lord, the writ petition disposed on 11/10/2023, my lord, till today they are not comply the order of single judge, my lord.
By not conducting Podi and those.
Yes, my lord, 136 subclause 3 proceedings, my lord, are concluded, the Podi and Durst.
Advocate Miss so and so submit that directions in period rate passed in order dated 11th October 20 by a single judge. They remained uncomplied with. Notice written on 8th November.
Much obliged, my lordship.
And by the complainant minute. Annexure C minutes, page number 25 minutes. On earlier occasion minutes, the learned advocate for BBMP minutes assured that the order of this honorable court minutes would be complied within 2 weeks minute. Page number 25 mechanics.
Notice written 7th November.
Please, one submission.
Number
I make apologies minutes. This complainant's mobile rang. I may be permitted.
21. Srinivas K.
My lord, I appear for the
complainant in this case. The order passed by the Slum Court, my lord, in the writ petition is at annexure, my lord, C, page number 39, my lord, is the operative portion.
13th notice.
So number 22,
Number the complainant.
is Jagdish Shastri.
Not the, this court has passed the order in the annexure number A, annexure A, my lord, page number 20, not to relieve the petitioners. My lord, now they are trying to relieve the petitioner, my lord, by passing the order, my lord, annexure C, Ashok.
Notice,
Suppression.
11th November.
Miscellaneous matter is coming on 4th of November, Ashok.
You are rendering service?
Yes, I'm reading service, Ashok.
Learned advocate for the complaint stated that the petitions are
Now they are disturbing, Ashok. Now they are disturbing, Ashok.
stated that the petitioners had been rendering service at the time when the order was passed
Yes, sir.
by learned single judge. Post of notice written on 11th.
Green bench matters, number 23, to Manjunath Ji.
And for the petitioner, my identical matter is disposed of in respect of annexure A notice issued by the second respondent.
They have not done.
Date of the notice as well as petitioner is date of the notice as well as petitioner is different.
This was in the same
Please.
terms.
Number 24, LM Chidanandaya.
It's been covered by Lordship's judgment. Form 29 of Forest Ramp, Lordship for passing the order. I've given the copy to government administrator.
My lord, could this be had on the 14th, my lord? I'll take notice. My lord may have this on the 14th.
Lordships have already passed similar order, your Lordships. Lordship says it. Page 5, para number 5.1, your Lordships. It's held that once the iron ore mineral is transported with Form 27, there would be no necessity to obtain Form 29 for the transportation.
Learned advocate, the petitioner stated that the subject matter and the grievance raised in this petition is covered by decision of the division bench of this court dated 4th March 2024 in writ petition number 29110 of 2023. In responding to this, learned additional government advocate, Srimati Nilofer Akbar, who is served with the advance copy of the petition, requested the court that time be granted to take instructions and verify the applicability of the judgment.
Lordships,
In the aforesaid view, put up at 2:30 on 21st of October.
Obliged.
Lordships, sorry for interruption. Para 6 may be looked of the order.
No, and I
This
don't
was told in
deny.
the Supreme Court order was that para 6 could be looked into, your Lordships. Your Lordships have expressed there. The government advocate had taken same contention. The order dated 1/2/2021 by the Supreme Court in the aforesaid special leave appeal figures on record. The order expresses states that no interim order is passed. Therefore, mere pendency of the Supreme Court to the appeal will not be a good ground to deny the relief to the petitioner when the law laid down by so-and-so holds the field. Lordships have held that interim order has been passed only with regard to
Relied
that.
on the decision of dated 4th March as a sentence. More particularly by inviting attention of the court to paragraph 6 of the order.
Much obliged.
But
Obliged,
everything is.
my lord.
Yes. Anything? You take dates.
Your Honor, I have a very critical issue, Your Honor. My serial number is 94. He's a senior officer retired, dismissed from service after retirement.
That can wait.
Medical cert-
My lord,
It
serial
will
number
wait.
34, my lord.
Afternoon, it may be heard, Your Honor.
We'll sit in the 3 o'clock.
Court officer? Court officer? Take dates on. So it won't be. That's what he said. We take dates on. Court officer? Court officer, are you able to hear me? He said, take dates on the way though. Not coming down. I don't think so. I don't know. But anyway, we are here, we'll check up. Go have lunch and come. 2:30 we'll put. Then we contact the court office. She's not taking up. I'm calling. Must be he's busy taking dates for other people. Let's wait for 5 minutes. Other people will go and ask dates. Court officer? Gita. Thank you. But then I'll put it again and see. 2:30. Indu, where are you? In the High Court, Vidya. Then you go to first court. They rose and went and take the dates at the 22nd one, which I think on the contempt to 35. Just find out whether they're given dates at the, they'll come and go to first court and see which date they given. Okay. Atva Madhyana Kaditara. I'm waiting here only. Okay. Thank you. Thank you. Okay. Good. Don't come. You have asked. The junior Bindu ಹೇಳಿದೆ ನೋಡ್ಕೊಂಬ. She will check up and come. Also, you can tell her to take a date. No, I don't know. My lords,
Yes.
may I make a mention, my lords? Serial number 40, it's a contempt matter. It's coming up for non-compliance of compliance affidavit by the respondent, which is the corporation BBMP. Now, complainants are civil contractors. About 1.5 crores is stuck with the BBMP and they are not ready to release the amounts in our favor. We have furnished the bills way back in 2017.
Serial number?
There's a urgency in the matter, if I may. Serial number 40. 40.
Or who will appear?
Maybe.
Oh.
So it is taken after vacation, after holidays.
Any date may be fixed immediately after the vacation, please.
23rd.
Please.
Serial number 34.
30.
The matter was heard for compliance on 21st August. Yeah, for 2:30 at on 29th August. Since then, this was never met and we were re-notifying the matter. Why is it that got re-notified and
But you are going to assault us? You are going to assault?
For that? Yes, my lord, I'm not getting my salary now. That day you were about to order and, my lord, let it be heard, my lord, just one line order. That day you heard fully, you are about to.
Which is the good day for you after vacation?
No, tomorrow, my
Auspice.
lord, tomorrow at 2:30, my lord.
Find out some auspicious day after vacation.
We have to sustain, my lord, no, sir. now 12 months are over.
It is contempt petition.
Yes.
Who appeared?
That day, that day my friend advocate.
File a reply.
We'll take up after this 1 or 2 matters.
May I make one request? You file a reply affidavit.
Lords, the matter is pending before the full bench, my lords. My learned friend is also.
Then we consider you can submit.
We have filed a reply affidavit.
So when we take up the matter, you can submit. Yes. We'll take up and see what is what.
It's all clear, my lord.
So wait till it is called out.
But when, my lord, tomorrow 2:30, my lord.
You want
Today.
tomorrow?
Okay, today, yes, my lord. Please.
You want today or
I'll wait.
tomorrow?
Today I'll wait. Thank you, ma'am.
Serial number 76.
70,
That is a public litigation.
76.
That is a public litigation, Lord. This honorable court directed the deputy commissioner to hold an inquiry. And after holding the inquiry, the respondent 11 enclosed 1.8 guntas of the land. Then, my lord, the deputy commissioner, honorable court director, and deputy commissioner handed over the charges, to take back the position of the property. Right after passing this order by the division bench of this honorable court, my lord, my learned friend, my lord, the opposite party, filed a writ petition and obtained the interim order of stay. Then I filed a including application that petition, there is no issue. No, my lord, after disposal of the public litigation, my lord, the respondent 11 filed a recalling application. That application is not maintainable because, my lord, he already challenged the learned deputy commission order before the learned single judge and obtained interim order. After that, he has filed this application for recalling the order of this honorable court. My lord, if you have any grievance in respect of that order, have to approach appropriate authority, challenge before the Supreme Court, not filing the recalling the order of this honorable court. This is my submission. My lord, the property worth of is more than 50 crores. 50 crores, he enclosed the property and constructed the building and sold the property to the various persons. Then the honorable court, after holding a detailed inquiry, more than 2 years, and passed an order. But after passing the order, the contesting party filed a writ petition suppressing the facts of the division bench order and obtained interim order. After getting the passing the interim order, he filed one more application because suppressing the fact, the real fact, the honorable division bench order and obtained interim order. Ee tara iddaga, intentionally they are suppressing the facts, obtained interim order, they are delaying proceedings. That's why, order kindly be dismissed that application recall. If you have any grievance, let them approach the appropriate court. Let him challenge before the Honorable Supreme Court. You have any grievance, but he has already taken the order from the single bench. Again, he has filed one more order application for recalling the order. This is my submission. But because I have no grounds to for recalling the order passed by this Honorable Court.
So you already made submissions. You already made your submissions? You already made your submissions?
Yes.
Then don't make on 23rd of October.
27th of October.
On that day, will not make any submission. You today made your submission.
But the thing is, intentionally, they suppress the fact. Interim order, then they are doing the same thing.
Today, not possible. Last day, 2 days, there are a lot of other work.
Immediately reopen.
Immediately.
More than 50 crores of rupees of the government land is enclosed. That is the problem.
Immediately on which date? Which date do you want?
Vijay Kumar.
No, Vijay Kumar, which date do you want?
Take immediately after reopening.
Tell the date.
14th.
14.
14th. Please.
I know this is a case where my house has been demolished 8 years back.
Which
For the-
number?
Against BBMC cases, 92.
92.
92.
On 12th February, I have got a favorable order from the favorable order, wherein I have been ordered to be paid 5 lakhs for, as compensation for mental trauma, 10 lakhs for the items in my house. Then CPWD has been asked to find out how much is the damage and reconstruct. Give me 10,000 rupees per month as rent. This was an order from the single judge matter. This matter somehow always appears in office objections. The BBMP shows a hurry saying that we want to hear it, but I don't know why they don't hear the office objection. And the matter, there is stay application, there is no stay, but I don't get any relief. The straight Article 21 case.
What do you want?
My lord, I want this matter should, at least the idea should be heard. There is no stay, otherwise they should be ordered to pay me the compensation. How long can I wait? They are not showing any urgency, my lord.
Immediately on reopening.
Yes, my lord, immediately.
21st.
21st?
With my lord's kind permission, may I make a mention, my lords?
Serial number?
94.
What do you want?
HA versus settlement is a service matter.
No.
Here, HA is a public sector company covered under the Ministry of Defense Production, and they are covered by CVC rules, Central Vigilance Rules. And anything is there, CVC has given a guidance, you get anonymous petition, don't action. In June and July 21, Secretary Defense Production, he sent 2 mails to HAL management. There are 2 anonymous petitions are there. What is the response? Give by tomorrow morning mail. Very important. What is the indications in the anonymous mail? Management has reduced the eligibility criteria by 1. Okay, that's all. The appellant respondent is physically handicapped, 62 years old. His research is suffering from cancer, undergo treatment. After retirement in July 22, May 22, they dismissed him from service in July 22.
on a false, imaginary grounds.
It
They
is-
got a mistake.
It is writ appeal. It is writ appeal.
Yes, HL has commanded them.
This is 94. Serial number 94. Writ appeal. Yes.
And respond.
Respond. Yes.
So, security, all the money has been recovered. And they made a false allegation, they got a stay in April 24, telling that except all others were paid. It is the other way. Except three, which has been paid to us, all others have stopped, including 60 lakhs. Pension has been stopped, medical facilities have been stopped, all the things have been stopped. And the reason is they got two anonymous petitions, which the ministry referred to management, asking what is your due by tomorrow morning. The allegation is management reduced the eligibility criteria for senior officer to be promoted, where it's required 2 years, if you have time only 1 year. That is one allegation. Second is directors, all others, the top management, they engage Indian Air Force aircraft, they went on soldier trip all other places. For this, they asked the question. And unfortunately, both the mails are gone from my IP address from residence.
Hello, it's
So,
No, don't get disturbed. It is.
both the mails are gone from my residential IP address. In HAL, the HAL IT unit can access anybody's mail. Without my knowledge, they can add. With my knowledge, anything also they can add and resume. On 25th August 2021, I was traveling from Chennai to Madurai by car. At the time, I'm getting a message from IT unit. You are sitting in helicopter and working, it's not your area. Are you working? Then he said, no, I'm not here. I'm leaving. Immediately called this office and told somebody is working, switch over the system. So once they got the mail, management thought, if you give this to police, they'll take care of it. So they were expecting a action there. But unfortunately, after police going through the complaints, they said it is civil in nature. Approach jurisdiction court of law. They did not do that. So then we approached the police, we got all the documents. Now, after getting this, things are not sufficient to harass me. I am eligible for having a company car to go and come from office. I am one of the top 30 officers in the company. Gentleman is a grade 9. Evening, the car comes, picks me up, drops me. Morning, it comes and drops. The car key is at the gate, car is within the company. Evening, today, 30th September 2021. Evening, when I car came, they attend something. 1st October, tomorrow morning when I come, sir, the hell you want to search your car? I am not, my car is not supposed to, because I am a senior officer. One in the 30th car. They went and opened, you are sitting around, okay, fine. Then, sir, you got the 4 CDs into the car. And they said it's porn CD. Driver doesn't know it is there, the passenger doesn't know, but security says it's available, they take it. So that's the included. Then other side, the case has become weak. Now after that, I don't question the management. They got absolute right in issuing charge sheet, conducting inquiry, punishment, anything and everything. Unquestionable authority is there with them. But when you do something, all the principle of natural justice, that's all we ask. The inquiry has never touched one word, Your Honor. Yes, in Honorable 7th Constitution bench in August 21, August 8.
7 judges or 9?
It's a year August 9 and another, they given a judgment to prove violation of the fundamental rights, no prejudice need to be done. Violation of principle of natural justice makes the act nullity. On that point only, now a complaint has come against the chairman. Chairman conducts the inquiry. He appoints the executive director, you conduct the inquiry. He gives a report, he goes through, yes, I agree. Then I give appeal, he goes through, he said, I don't agree. I give a punishment, everything is understood. I give to board of directors. Then I give to board of directors of appeal.
Why some people are smiling? Yes, you continue.
No, they have taken a stay and then vacated orders of the single judge has been upheld. That is also the thing I take. All my amount has been withheld and no medical facilities and the serious issues at home.
That is all.
Limit of the holidays.
No. Writ appeal is allowed. Writ appeal is allowed. Writ appeal is allowed. But you argued it and we allowed it. You argued the appeal without anybody inviting you to argue. And we allowed it without inviting anybody to dismiss it. So let it be after vacation. So it could have been a one-line request.
Sorry, Your Honor, I take it as
So which date will suit you? To take advice of your counsel, which date will you suit? 23rd, 23rd. No, we are patiently here. Please. Doesn't matter, but there is a paucity of time, so we'll take up after that.
List number 3 for pronouncement of judgment. Writ petition 15,313 of 2024.
So this is 15,313 of 24. You are for petitioner.
Please, Your Lordship.
For all the foregoing reasons and discussion, the petition succeeds. Impugned order dated 31st May 24, passed by Disponor 4, is hereby set aside. The disqualification of the petitioner as member of the Karnataka State Pollution Control Board is annulled. Consequently, the petitioner's dismissal from the post of chairman of the Karnataka State Pollution Control Board is set at naught. In normal circumstances, this court would have reserved liberty for the respondents to proceed in accordance with law. However, looking to the aspect that the petitioner's term expires on 14th November 2024 and only 1.5 months is left, no further observation is made. The petitioner shall be continuing to be the member and the chairman of the board till his tenure expires, as per notification dated 15th November 21. As if the petitioner has continued throughout with entitlement of all consequential benefits.
With my lord's kind permission, may I make a mention, my lords?
Pardon?
May I make a mention, my lords, with my lord's kind permission?
Mention, yes.
My lord, serial number 87. Last when it came up, my lords had directed it to be listed today, but for some reason it is listed for non-submission of copy to the other side. But the copy to the other side was submitted in advance itself, my lords. And there's some urgency in this matter, my lords, because I have been shut for the past 1 year without any recourse to law, because they have been giving me permissions and seeking them back, taking it back. If my lords could have it tomorrow, I'd be very grateful, my lords.
Your Lordship, appearing for the Respondent Pollution Control Board, senior is not available tomorrow for arguments. So it may be had after, on the reopening day.
This man.
Yes, yes, Your Lordship. It may be had on the reopening day of the court. We'll argue and place the documents on record, Your Lordship.
Reopening,
Yes,
25th.
yes.
25th of October.
My lords, can it be earlier, my lords, because
Earlier is when? When do you want?
14th or 15th, my lords? Not 15th, sorry, 16th.
No, that is not possible because only 3 days are working in that. 25th is all right, yes.
Grateful, my lords.
First 4 matters. List number 2, still number 9. Mr. Yatish, yes.
You're not taking. Education. This will not survive.
It doesn't survive because interim order was granted.
Where is the petition?
OCI, but
Where is the petition?
morning also was not.
So can we record your statement and dispose it?
Yes, no. Because in the light of the interim order granted, you must have taken a seat also. And 28/6 interim order was that. PBBS nursing. Or else, but your lordship may have this after, immediately after the vacation, I'll see whether she has taken any seat. Immediately after the vacation, lordship may have it.
It is taken or not, it is not our job.
Yeah. ಏನಿಲ್ಲ. ಎಲ್ಲದೂ ಕೇಳಿದ್ದಾರೆ. BSc nursing ಎಲ್ಲದೂ ಕೊಡ್ತಿದ್ರು. Except medical.
The petitioner student filed this petition making following prayers. Quote from page 26. Roman 1, Roman 1, Roman 2, Roman 3, Roman 4. Up to page 28. Paragraph. By order dated 28/6/24, this court granted aid and relief to the petitioner, directing that the petitioners, not petitioner, directing that the petitioners shall be permitted to participate in the online counseling for admission to the undergraduate courses in medical, dental, and engineering for the academic year 2024-25 for both government and private seats, treating the petitioners at par with the citizens. Not only that, the aforesaid interim order has worked out for itself, paragraph. Not only that, the aforesaid interim order has worked out for itself, and the counseling for admission is over.
But it is going on.
Counseling of the
2004-5.
two rounds of the rounds of the counseling for admission are over, and the mop-up round is
Yes.
underway,
Yet to commence.
wherein the petitioners are permitted to participate as per the interim order, the subject matter dispute, subject matter issue. The issue involved in the petition has already been decided by the Supreme Court in Anushka. So and so,
Anushka
give
Sharma.
the citation. As well as in the decision of the division bench of this court in ABC versus XYZ, which was writ petition number so and so, so and so, so and so, decided on so and so, so and so, so and so. Full stop. The petitioner shall enjoy the rights for the petitioner shall flow from the decision in Anushka, Raghunath for Supra, and Maravala.
Meghna
Our
Kudwali.
the citation is this Anushka.
Meghna
Supreme Court,
Kudwali.
Anushka. For this. Our
Meghna Kudwali, 71 J. So we first separate.
that will not come.
That's the first part will come.
Chair will. As well as per the order. Supreme Court as well as per the as per the order in Nachiket Kiran Govekar versus State of Karnataka, which was writ petition number 10716 of 2024, decided on 5th August 2024. The petitioner herein shall be entitled to enjoy and enforce the rights, as per the aforesaid decisions for seeking admission. The petition is disposed of accordingly. Full stop. It will be open for the petitioner to revive the petition or filing interim application in case of any genuine difficulty. You will get this and
States with OC as well as 371 both issues.
this as well as this. So this Nachiket Kiran Govekar as well as Meghna Puruvalli versus State of Karnataka, which was writ petition number 315400, as well as the decision of this court in so and so, Meghna Puruvalli versus so and so, which was writ petition number 15400 of 24, decided as per judgment dated 4th September 24.
Vasant Kumar HT, C number 11.
Which?
My lords, I am appearing for accused, my lords. We already filed complaints, my lords. None of
He is not there. 10 out to 29th of 29th of.
List number 1, C number 34.
None.
My lord.
Number 34.
I'm the petitioner, man. And the other day on 29th August, when you heard the matter and he asked for time, you adjourned it by noting and at 2:30, my lord. And it was regarding the compliance of the High Court order, interim order, which is at page number 13, my lord. Annexure A 13, wherein I am continued as professor. Page number 14, para.
No, what is the problem?
And it has got the attention of the Supreme Court also, my lord, at page number 269, 270, my lord.
if I
What
could,
is the problem with you now?
Yes,
if
my
I
lord,
could.
I'm working as professor, man.
What is the problem in this matter? What
They
is
are
the
not
grievance?
paying me salary, my lord. They're not paying me salary nor giving me the workload, though the interim order is there.
So
It
petition
has
is
past
pending.
1 year.
Petition is pending.
But it's petition is pending.
Petition is pending.
Please, please.
That is before the 3-judge bench, my lord, reference court.
3-judge bench.
3-judge bench, my lord.
No, this learn a single judge, it is pending.
That has been posted before the 3-judge bench, my lord. If you observe in the same
Gone before a
order,
larger bench. The issue
since it is
involved in the
there-
matter has gone before a larger bench. This
reference,
There are two
Of Supreme Court.
No, before this on.
for this on.
honorable 3-judge bench.
There
is
will constitute a larger bench.
That's what, my lord. 3-judge bench is constituted and it is going to be heard.
We
Before that.
constitute.
But the interim order has to be, complied with, my
This
lord.
is interim order. We are not going to entertain.
My lord, can I take you to Annexure E, my lord, 269, 270, my lord, where the Supreme Court has observed, when I went before the Supreme Court, it has said, if the management has failed to comply with such a direction without any ground, the petitioner shall be at liberty to approach the High Court. Because I am not getting my salary nor retirement benefits or whatever.
There are two reasons.
Yes, ma'am.
There are two weighty reasons. Right. There are two weighty reasons as to why the court is not entertaining the present contempt petition. First is that the order is interim order. The proceedings of the main petition are pending at large, yet to be decided finally on its merits. By very nature of the order, some of the rights of the parties are not finally crystallized.
My lord,
In that view, the court is not inclined to entertain the.
Annexure E, my lord, Supreme Court has made a
that view,
reference, my lord.
The court is not inclined to entertain the contempt petition. Full stop. Will be open for the petitioner party in person to petitioner to work out his rights and remedies before the learned single judge where the parent proceedings are pending. Secondly, paragraph, it was stated jointly by learned party in person, Mr. So-and-so, as well as learned advocate, Mr.
Varun Joshi.
Varun Joshi.
Varun Joshi.
For respondent,
Accused number 1 and 2.
2,
1 and 2.
1 and 2, as well as learned additional
Pramodini government.
government advocate for
3 months.
My lord,
Pramodini for
your last statement, my lord,
that
on
the
that
issue
day,
involved in this case is referred to
you have made a reference, my lord.
the
in
larger
this regard.
bench. Full stop. Full stop.
Page number 270. my lord.
Parties shall abide by the decision which may be rendered by the larger bench and in the writ petition. Full stop. Contempt petition is not entertained according.
My lord, page number 270, my lord. The management fails to comply. Supreme Court has made a reference, my lord. And last time you had made a reference to this point, my lord, and that they had to pay. And you called it on the next date. After that, we never met, my lord. They have said management fails to comply, I can approach this court, and that is why we are here with the contempt petition.
Lastly.
Number 63. MS Chandrasekhar Babu.
What is the urgency?
Operative portion, page number 17 minutes.
Page number?
Operative portion of the order is that in page number 20 minutes.
21. So what are the directions? Reconsider representation.
We are,
So they will reconsider. When you will reconsider?
respond number 4 is directed to reconsider. Respond number 4 is served unrepresented minute.
Not appearing.
And the honorable court has directed me to produce the document there. Your lordship kindly have a look at page number 17 minutes, para 6 minutes. Para 6, it says that it need not be reiterated that a government order dated 26/4/2013 enables the applicant's sandbox herein to get pension by adding shortage of period and make it as 10 years minutes. 1982 and 2013 orders for their notifications for their minutes. I have produced the order. Your lordship directed me to produce the notification minutes. I have produced it on 24/2024 minutes. It is clearly stated in this minutes. The former Shanbogs who did not complete the minimum period of services required for pension benefits and served as village accountants are also eligible for pension benefits as per the Karnataka Civil Service Rules 247A and the opportunities available under the government order dated 1977, 28/11/1973. Despite this, my lords, during the pendency of contempt petition before the Honorable Court. The respondent has issued endorsement, my lord, stating that 247A is not applicable to petitioner, the complainant before the Honorable Court, my lord, sir.
Where is your opponent?
No,
Vote number 4. Your vote number 4.
R4. Respondent number 4 also. Respondent number 4 is the accountant general. Millards. And in the earlier bench, Millards, the division bench of this honorable court directed me to produce a memo of calculations also. Millards. I have produced a memo of calculations on last date of 2030-23 December itself. And also the respondent number 4, respondent 1 to 4, have withdrawn the due to displeasure taken by this honorable court in the division bench matters. They have withdrawn the endorsement matters. That is also there in the, it is there in, as on 11/9/2023, they have made, they have withdrawn the endorsement stating that endorsement amount to aggravated contempt, and hence endorsement was withdrawn, my lords. The petitioner.
This is the matter, your lordship, where when the Village Abolition Act came in force, the officers were attached to the revenue department. Before the act came into force, they were continued as in those posts such as the Kulkarni, Shanbogs and other things. Now, this complainant here in my lord joined the office in 1963, your lordship. There they said their services will be regularized, they'll be entitled for pensionary benefit only if they have completed 10 years of service thereof. But only service that was left for this complaint, your lordship, was 8 years, 3 months and 29 days.
You decide the representation. That is the only reason.
Yes.
Why you are not deciding?
We've already issued endorsement. Endorsement was issued.
No, endorsement was issued, my lord. There was no subsequent to endorsement, my lord. This honorable court heard the matter and directed me to produce the memo of calculations and also the notice.
And similar matters, similar content matters.
Where is the endorsement?
The 10 years relaxation has been overruled, my lord. My endorsement is misguiding the.
Where is the endorsement?
In the endorsement.
It was filed on 21st of February 2024.
Page.
Along with a memo, your lordship. 21 Feb 2024.
Page.
Page 2 document. Page 2 document number 1.
Can we not find out the page after vacation? We'll find out.
15th, my lord.
15.
15th, I am ready.
15. What? 15.
My.
Yeah. All interim orders.
My lord, serial number 69, my lord. My lord, serial
Yes,
number
yes.
69. My lord, it's a contempt matter, and now the father and the mother, they had a mutual divorce and they had to share custody of the child, my lord. It's been 6 months that they have cut off all the communication, and now the mother has filed a POCSO case against the child, my lord. Against the father, my lord. My lord, kindly, it may be heard tomorrow, my lord, in the beginning of the list.
Tomorrow not possible. We'll postpone it to after vacation. Your mentioning is postponed.